Good morning. Anybody there?
Morning.
Good morning. I'm actually
I'm good. How are you?
pretty good.
Good. Bear with me 1 second. I'm having a speaker issue. Okay. Can you hear me okay?
Yes, we can hear you.
Perfect. Perfect. Okay. So we're going to talk today, I think, for the first portion about handling offers that are over asked. Yes. I wanted, this is obviously a real significant issue that we've all seen. And, actually, let me take a step back. I apologize. For those of you that don't know me, my name is Benjamin Dash. Please feel free to call me Ben. My practice is grounded in real estate and business transactions and litigation in both areas. In my practice, I represent buyers and sellers in residential and commercial real estate transactions. I represent real estate brokerages, real estate agents, title agencies, lenders, home inspectors, surveyors, engineers, pretty much you name it. Anybody that touches real estate transactions are clients, developers, builders, speculators, hard money lenders. We represent everybody really that touches real estate transactions in some capacity. We also act as general counsel to a number of those companies, providing them with a variety of legal responses to issues that they have and so forth. Within that realm, we handle many different types of transactional issues other than just traditional purchases and sales. So if you ever have needs or anything like that, please feel free to reach out. And please feel free to reach out to me with questions. I'm always happy to answer questions as best I can for agents in offices that I have a working relationship with. Usually the best way to do that is by an email, and then typically I'd be happy to set up a call with you just if you're having issues, happy to try to help. So with that, we're going to talk first about how to handle offers that are over ask with regard to the contract itself, because this has proven to be, in my experience, and I'm guessing you guys have had potentially similar experiences where you get an offer and it sounds great. You're asking $200,000 for property. Now you have an offer for $250,000, and the seller wants to throw you a parade. And next thing you know, your deal's not closing. And so what I want to talk about today really is how do we handle that? What are the things to look for at the time the offer is received? And how do we write this up in a way to make it as close to bulletproof as we possibly can? And so, to begin with, we'll use this hypothetical of this $200,000 property that's now going to trade at $250,000. Assuming that you've done your homework, which I'm sure you all have at the time that you list the property, and 200 is a reasonable estimation of what the property's worth. When you get an offer like this, the very first thing you have to look at is what's the form of payment? If it's a cash offer, fantastic, we can stop this class now. If it's a cash offer, we're gonna write that up. The buyer waives the right to any appraisal contingency or anything like that. You may have experienced, as I have many times, the mere fact that someone's a cash buyer doesn't necessarily mean that they're not looking to do an appraisal. I've had many times where I've represented cash purchasers and sought to put an appraisal contingency over the years, sought to put an appraisal contingency in the contract, and the other side says, well, what are you doing? This is a cash buyer. And the answer is cash buyer shouldn't have any less rights than any other buyer would. And if this was an FHA deal and we were at the other end of the spectrum, there would be an appraisal contingency. So in this market, when it's an over ask offer cash, you want to make sure that a buyer has waived their right to conduct an appraisal, or at least an appraisal contingency. But other than that, you also want to, with any cash offer, as you would with any cash offer in any market, you want to see a proof of funds before you put a contract together. And you want to make sure that that proof of funds, number one, is liquid. I've received, I can't tell you, especially in this market, how many proof of funds I've received that are retirement accounts. And so if you see a proof of funds that comes through a retirement account, that's okay, maybe. You need to start now asking questions. How old is the buyer? Is the buyer able to take cash out of that account, and how long will that take? And if they're not old enough to take cash out of that account, are they able to borrow from that account? Not all retirement accounts are created equal. Not all of them allow somebody, the owner of the account, to borrow against it. There are many different types of retirement accounts. So you'll need to check that. Is this an actual account that's liquid? Number one, and number two, is it a retirement account? You need to start asking those questions. You also need to watch that the proof of funds is in the name of the buyer. I get this frequently where, Hakan Karahan is the purchaser of the property and he makes a cash offer, but the cash offer comes in HomeSmart Realty's bank account. And we need to start asking questions there. Why am I getting proof of funds from your business when you're the buyer? Who is the actual buyer, you or your company? We need to start asking those questions. We get those a lot. We also get, and this is something that you want to flesh out in the beginning. Well, yeah, I'm cash, but my Aunt Sally is giving me the money. That's not a cash buyer. That's somebody that's getting a gift, and that's a very different ballgame altogether. Now we need something from Aunt Sally, bringing her in as a party, showing that she is in this deal now, because her promise doesn't do a whole lot of good for your buyer, for your seller. When the buyer shows up to Aunt Sally's house for dinner wearing a Make America Great Again t-shirt, and she looks at him and goes, I had no idea. I'm not giving you any money now. That's not a commentary on the president. I'm just giving you an example. But in any event, you want to make sure it's not a gift. You also want to make sure, I see this a lot as well, that cash isn't coming from the sale of a piece of real estate, or isn't coming from a home equity line of credit or some other type of loan. You want to make sure that this is really cash on hand when you get a true cash offer. And I've seen many purchasers who don't mean it to be deceptive, but they just don't know that, for example, they don't know it's relevant to tell everybody, yeah, the cash is coming from the sale of our house in the Poconos, or the cash is coming from a gift or a loan from Aunt Sally, or something else. When we all hear cash, we just assume that buyer's got cash in the bank and so forth. That's funny. Chris, that's good. In any event, so we really want to vet out those cash offers. And really, if you get a cash in this market, all you really need, once you've vetted the offer and the buyer, really all you need at that point, like I said, is to put in the appraisal waiver language in section 43 of the contract, just to ensure that everyone's on the same page from the start. Let's now swing to the more interesting and complicated scenarios of, I made the offer of 250 on a house that's 200, and now I need a loan for 230,000. This is where these deals tend to spin out of control. In section 43, I've seen all kinds of stuff written up in that section as to sort of the approach and how people are going to handle it and so forth. Here's the bottom line. If the house is worth 200, there's absolutely no way that a buyer is going to get a loan for 230,000 and it's going to appraise for 250. We know right out of the gate that that's not going to happen. And so writing up bringing that offer to your seller, the seller is going to be thrilled. Now, in about 2 weeks, when the appraisal comes in at 200, they're not going to be so thrilled. So the way that we need to approach that is this: a conversation needs to be made with the buyer's agent of how are they planning to handle the difference, because we know the house is not going to appraise. How is that going to be handled? And oftentimes the answer that I hear is, hey, the buyer is going to bring the cash to the table. Well, that's fine. But what we need to know is if the house is really worth 200 and they don't want to pay PMI, they're going to do an 80-20 loan to value. Now we're talking about $160,000 mortgage on a $250,000 house. So we need to make sure that when that happens, that these people actually have, again, we revert back to proof of funds. Do they have $90,000? Do they have the actual money that they're going to need to do that? And you have to vet that deal right then and there, so you're not setting this up for failure. We want to find out immediately, does the buyer have the cash? Is the buyer willing to bring the cash to the table? Because many times I've found the buyer's agent isn't having that conversation with the buyer. They've been, running all over God's green earth looking for a house. They've been outbid on 10 houses already, and they're just so happy that their bid was accepted. Nobody has necessarily stopped to ask, how are we going to get the deal done? And so just because somebody's willing to pay that, that's great. But if they need a mortgage, now we have this issue. And so you have to literally sit down and do some quick math and see what's this going to end up looking like. If this is, God forbid, an FHA buyer or a VA buyer, you're going to need to find out right away, do these people have the money? Because we know that's not going to happen. You're not getting a 3.5% down if you're 50,000 over asking price, or 0 down if you're 50,000 over asking price. You got to have the cash on hand. And so in those scenarios, you need language either in section 43, pardon me, or by addendum that states that the buyer acknowledges the asking price is over, strike that, the sale price is over the asking price, and the buyer agrees to bring whatever cash is necessary to closing if the house does not appraise for the sale price. That needs to be built into the contract right away. And so I found with this that many deals fall apart right then and there because the buyers really don't understand sometimes what they've agreed to. They don't understand that they're really going to have to bring a lot more to the table than they thought they would. And so you really need to flesh those out. I find with these offers that some of them stick, I think, if they're properly vetted, but many of them do fall apart. I get calls frequently during the transaction with, use the same hypo, $200,000 asking price, 250 contract price. The appraisal came in at 200. And now there's this argument between the two sides of what are we going to do? And the answer is there's not a lot we can do at that point. You have a contract that says it's contingent on them getting a $230,000 mortgage. The house appraised for 200. The mortgage got denied. And so you really need to closely look at these and carefully write them up right at the beginning so that they don't fall apart. I will tell you that, in this market, look, I've been doing this for about 20 years. I've handled about 4,000 real estate transactions in my career. I've always felt that parties need an attorney in a transaction. I often when I'm speaking in an office, depending on the topic, I usually bring a little map of the state of New Jersey broken into counties, the 21 counties, and I've blacked out Burlington, Camden, Gloucester, and Salem, because the other 17 counties, if you go further south, you go east of the coast, or you go north of Burlington County, the other 17 counties all use attorneys all the time. And so here, we don't see attorneys as much. I think in Burlington and Camden right now, I would say it's probably maybe 50% of the time, more than I've ever seen. But I think that right now, sellers need attorneys more than ever. I used to say if I had to pick one, I would typically pick a buyer. But I think that sellers need counsel now in order to keep these deals together. Because we'd rather know right now, when you've got multiple parties bidding on this property, you'd rather know now at the start whether or not you're going to keep this deal together versus write the contract and cross your fingers until the appraisal comes in. And then we've got to start the process all over again. And maybe the other 5, 6, 7 people that were bidding, now they're committed to other properties, and you've got to go through this process all over again. And you now have a very angry seller, which I've seen. I've seen, sellers who are throwing daggers at their agent because they say to me, how could they let this happen? How could they take me down this path? And so it makes, in my opinion, far more sense to ask all these questions right at the beginning, flesh it out, vet the deal, vet the buyer, put it together that way. And then we know as we're going through it, whether or not we've got a deal. If we can get past this issue, the only real remaining issue is inspections. And so, inspections are always an issue, regardless of the market that we're in. They are less of an issue now because, in some regards, because buyers are willing to accept much more than they were before, because they, if they've had their offer accepted and they have a contract, they feel like they're holding Willy Wonka's golden ticket, and they're very fortunate. But one of the things that I often see in Section 43 or by addendum is really loose language related to those inspections. And oftentimes that language will say something like, buyer waives all rights to inspections except for major things, or buyer waives all rights to inspections unless any item is more than $5,000. Those they're okay. Those sentiments are okay. The problem is the way they get written up is sometimes where we find problems. And here's what I mean. Nobody can define major items, or sort of one of my favorites, structural. It's very difficult to define that. And things that are structural, some structural problems can be, from a dollar standpoint, very minor. They can be in the hundreds to cure. And there can be some problems that aren't structural that are in the thousands to cure. And so when we say major things or structural, in my opinion, it's way too vague. And so also when we put in a dollar number, I think that we sort of set it up for failure. And here's why. I think that, again, sticking to my 200 ask and 250 sale price, if we've written it up right and the buyer now has committed to paying all this additional cash that they're going to have to pay and so forth, or bring in this additional cash into the deal, they're already kind of, the glow is off of the deal. Once we're into inspections and things like that, they're thrilled in the beginning that they got their offer was accepted, but now that's kind of worn away a little bit. And now they're in the inspections, and all of a sudden, when they say, oh, it's got to be 5,000, if it's under 5,000, they're taking it. If it's more, they can negotiate, or the buyer can cancel. All of a sudden, the buyer goes, wait a minute, I'm paying $50,000 more than this house is worth. I got to bring all this extra cash to the table, and now I've got to eat this problem, this problem, and this problem. No, something's got to give. And so the issue we have with that, when we have a dollar figure in the contract, is, as I'm sure you all know and can do, I can get a contractor out that has, where there's a problem, to give me an estimate for $7,000 for a problem. I can get a contractor to give me an estimate for the same thing for 700. And so it's 5,000 according to who? When you put that dollar figure in the contract, 5,000 according to the buyer's contractor, 5,000 according to the seller's contractor. And now what do we do when it's not stated according to who? What do we do when buyer's contractor says 7,000 to repair, seller's contractor says 700? Now what do we do? Again, we have this stalemate, which is what you want to avoid. You want to avoid all of these speed bumps and pitfalls. And so I'm generally not a fan of putting a dollar figure in the contract for that reason. I'm also not a fan of putting in like these vague terms. It just says like major structural issues and things like that. And so typically what I do is I'll insert in the contract that the home inspection requests are limited to material defects. And then I actually put a definition in for material defect. And I think this is one of the problems with the agreement of sale that we have right now. This agreement, by the way, when we went to this statewide contract in 2015, we're in like the third or fourth iteration of it. But when we went to this statewide contract, then I was in the middle of a 3-year term as president of the Burlington County Bar Association Real Estate Committee. And I was asked by NJAR with a handful of other attorneys to review this draft contract that we're going to finally start using on a statewide basis. And one of the things that I, and I think several of my colleagues commented on, was this language in section 16 related to how are we handling this? And so, I imagine you're all pretty familiar with section 16, which basically says that the buyer is buying the house as is, but, and it's what I refer to as the world's biggest but if there's a defect in the property, the buyer can ask for a repair. And if the seller doesn't agree to repair, the buyer can cancel. And so this is, in my opinion, I think in the opinion of most attorneys, an extraordinarily buyer-friendly provision because there's no working definition of defect. It just says if there's a defect. And so what I typically do when I represent a seller, and in particular in these transactions, what I typically do is I will include what I call a material defect standard. So every home inspector that's licensed in New Jersey actually has to follow, there's a body of law for home inspectors under the New Jersey Administrative Code of how they have to handle a home inspection, what they should have with them during a home inspection, and how do we define a material defect. It's actually defined in the New Jersey Administrative Code. And so I'll put in the addendum, even if I represent a buyer. I'll talk about it with the client. I'll talk about it with both of the agents. What was everybody's understanding? And I think everybody's understanding was it's got to be something huge. When we say material, it's got to be a major item or structural defect. So by doing this, I put in the addendum, the parties agree that the buyer can only request repairs to material defects as defined by the New Jersey Administrative Code, and actually plug in the definition right into the addendum. It's basically got to be a defect that causes a substantial loss in value related to structure, major systems, and so forth. And it's a really nice working definition. And this way, when we've already vetted the buyer, we made sure the buyer and proof of funds match, we make sure they've got the money. This is really our only last hurdle on these deals. Now, when the home inspection happens, we're not going to get this ridiculous list trying to create a second round of negotiations. What we're going to get is if there's a legitimate material defect, we can talk about that. If there isn't a material defect that substantially impairs the value of the property, that's beyond the scope of the contract. We're not having that conversation. We're no longer talking about windows that have lost their seals. We're no longer talking about, the front door lock is missing a screw and stupid stuff like that we often get tied up in. And so in any event, that's what I recommend building into these deals. I think even when I represent a seller, when I get sometimes a contract that says the buyer waives a right to all inspections, I actually tell my clients who are selling, you don't want to do this. This is a great way to get sued. I will tell you, a tremendous amount of post-closing failure to disclose litigation. And we've represented everybody in these transactions: buyers, sellers, brokerages, home inspectors, engineers, and sued all of them. And I will tell you, the last thing that a seller wants to do in this market when they're selling a house well over ask is not afford a buyer the right to conduct an inspection. You can draft language that makes it very difficult for a buyer to ask for something as a result of those inspections, such as what I'm talking about. But I'll actually recommend to my clients that are selling, do not let this buyer waive their inspections. It's going to come back and bite you in the butt. I see it every day. So normally we'll talk about that. And usually when I get these deals, when they have these types of terms in them, I'll typically reach out to both agents, the listing agent and the buyer's agent, and just say, what was everybody's sort of, what was the actual meeting of the minds? Forget the stuff in the contract. What did everybody actually agree to? And then we build out from there. And in doing this, I'm not going to tell you deals that I work on, I have 100% of them closing. Of course they don't. But I will also share with you that a very high percentage of them make it to closing because they get really properly vetted in the ways that I'm talking about. And I think that it's real important for you guys, in order to keep your deals together, to look at them through this lens, because there are a number of pitfalls, particularly when you're selling these properties like this. And so with that, I'm going to turn the floor over to you guys and allow you to ask me, any questions you have about any of this. And if we have time, certainly I'm happy to talk, take questions on any other topics you have. Anybody? Let me look at the comments here. Okay, this is what I use on section 43. Any suggestion for changing it? Okay. Buyer shall supply to seller as far as agent a list of buyer requested repairs, maintenance, cosmetic items that are included in the inspection report or for buyer's information only are not covered by provisions of this paragraph. Yeah, Hakan, I actually include what you have almost verbatim in the same section. I take that, I put this in after after I define material defect. I actually do both because home inspectors, it's a thankless job. If they don't write enough, they get grief, and if they write too much, they get grief. But so they end up frequently. I'm sure you've been in this industry a long time too. Home inspection reports are now like this, 120, 130 pages, where they used to be like 10 pages. And so what I end up seeing is a lot of times they write these things up. They look like defects, and they're really maintenance requests, maintenance suggestions. And so I include that exact language, pretty almost exact. I include that, but I include it after I've defined material defects only. So that the scope goes down to about that of what they can actually ask for. Because I think that whether I represent a buyer or a seller, I think there's way too much emphasis on the home inspection. It wasn't intended to turn into what it has turned into, which is a second round of negotiations or a possible way to get out of a contract if you want to. That was never the intent of a home inspection. And there really are, they're just visual inspections. It's like going to your family doctor with pain in your stomach. They can kind of poke and prod, and they have information, and they certainly know things, but they can't see inside of your stomach. A home inspector can't see inside the wall, the ceiling, whatever it is. And so they can only really make, in most cases, general statements. So I like that, but I further narrow the scope to include that material defect standard.
Hi, Ben.
Hi.
Hey, going back to appraisal waivers, do you have any recommendation for language where the buyer may be willing to not bring the entire difference in cash if it appraises low, but up to a maximum of like $5,000 or something like that?
Yeah, I do see that. Are you saying, do I have specific language for that? Yeah, I mean, we generally will put in, again, using the same numbers. So let's say the buyer is willing to bring, up to 20,000. We'll put in language that says, in the event the property does not appraise, buyer is willing to bring in up to $20,000 additional required cash to closing. We put that in, you can put that in, but if you're representing a seller, I think you're doing the seller a disservice by agreeing to that, unless you just don't have a better offer, because you really, that property's not going to appraise for where you are. And so you really, even though you took the offer at 250, going into it that you're really only going to get to 220 because the property is going to appraise around 200. And so I think if you're on the listing side, I think you're doing your seller a disservice with that. And in this market, typically there's a better buyer if that's where you are. But if you don't have a better buyer, then yeah, I would put language like that in. I'm not a big fan of the language I see sometimes. It says the parties agree to negotiate. Again, it's, in my opinion, it's just too darn vague. And I think vague is great when you're looking to make an argument because it allows you to sort of zigzag in a lot of different places. But if you're actually focused on trying to get the deal to the table, I don't want vague. I want very tight terms. So I'm generally not a fan of it.
Thank you.
Yeah.
Did you go?
What's that?
Hey, Ben, it's Hakan.
Yep.
Why do you guys always pick on our commissions? Leave that section.
All right, let me start here. It has nothing to do, I know a lot of agents say, these damn lawyers, why do they do this to us? Why don't they like us? It's not that at all. I'll stop and tell you guys, I'm married to an agent. I know the hell you go through every day. I do. I respect it. I respected it before my wife became an agent. She's been an agent for 10 years. It has nothing to do with that. Here's why. This contract is a two-party contract between a buyer and a seller. I tell no matter which side of the deal I'm on, because I do take it out in my buyer addendum and in my seller addendum. And I tell my clients, whoever they are, buyer or seller, the same thing every time. The agents are not part, the brokers, I should say, are not parties to this contract. There shouldn't be rights of a party that isn't in the contract. Parties that aren't part of the contract can't have rights in the contract and shouldn't have rights in the contract. What you are as the broker is what's called a contingent beneficiary or third-party beneficiary. You have rights based on and contingent on the transaction closing. And so what I tell my clients is this: I agree with all of those paragraphs. I agree with every part of them, and they're all accurate. But it doesn't belong in this contract, and nor does it need to be in this contract. This is someplace I think that the NJAR and attorneys differ with regard to the opinion on this. It's not that we disagree. You, in my opinion, have an equitable lien. In my opinion, if I'm the buyer and I wake up one day after we're under contract and I say, you know what, I don't want to pay $250 for that house, I'm just not buying it. Whether or not that term is in the contract, you have a right to sue me, period. Your brokerage has the right to sue me for your commission. Both brokerages have the right to sue me for commissions. Whether or not it's in the contract, that's immaterial. It's a breach of contract. And by virtue of being in this deal, you have that right. So it doesn't need to be in the contract. So it's attorneys do that really to clean up the contract from having terms that are unnecessary. And so it has nothing to do with the belief that that the brokers and brokerages and agents are less than. It has nothing to do with us not agreeing with those terms. I think just about every real estate attorney out there would tell you, yeah, I agree with that. Of course, that makes sense. It's just a question of a contract having language in it that isn't appropriate, and that's why. Yeah. What else?
Hey, Ben. I actually did had a question about as is sale. Can you expand about it a little bit? I know a lot of the time buyers, they either want to go back and negotiate about as is sale, or they just want to cancel the contract, although it actually says inspection is for the buyer's knowledge only. So at this point, I know a lot of it with real estate is just communication, how well you express your expectations from the buyer side or the seller side. But if something is not communicated correctly, that buyer or seller can either get upset because they felt that they didn't know something or somebody didn't explain something well enough to them as to what an as-is sale was actually. So I don't know if you have anything to expand on that.
I do. It's a great question and a great point. I always, it makes the hairs on the back of my neck go up when I read a contract. Section 43 says inspections are for buyer's information only. Because typically I may read that as a buyer and think that it means chocolate. You may read that and think that it means vanilla, and the answer might be strawberry. We have no idea. And so typically when a seller gets an offer that's as is, the seller feels I've got a buyer on the hook. They're buying this house no matter what. You want to do an inspection? Do an inspection. I don't care. Do 100 inspections. You're buying my house. Buyer says, okay, I understand that the seller's not going to make any repairs. They're not going to give me a credit. They're not going to do any of those things. But in exchange for that, I can conduct inspections. If I don't like what I find, I can walk away. I have walkaway power. And so that sentence, it's for buyer's information only, doesn't mean either of those things. It doesn't mean anything. It's really, in my opinion, a recipe for disaster. I see it a ton, but it's a recipe for disaster. And so I think, legally speaking, and I've argued this case, this issue in court both ways, on both sides of the deal, more than once. And I'll tell you right now, there is no answer. And so if you have a buyer, if you represent a seller and you have a true as is deal, the only way you have a true as is deal, in my opinion, is when you have language that says the buyer has inspected the property, the buyer is satisfied with the results of the inspections, the buyer waives the right to conduct any other inspections. That's the only way you have a true as is deal. Once inspections happen, there's no, and here's the argument. Why, if you're a buyer, if the reality is that you can't do anything with that information other than have it, why are you doing an inspection now? Why don't you do it the day after closing? And so that question is what opens the door to what was the buyer's expectation when they conducted that inspection before closing. Why would anybody bother doing that? Who cares? If you're buying the house, if you're locked in and you're buying the house no matter what, you don't need that. You could do it next week, next month, next year. Who cares? So, and this is why when I get contracts that have language like that, I generally start making calls to whoever, to my client first, and to the agents. What did everybody agree on? What was the actual deal? Forget what went into section 43. What's the actual deal? And oftentimes I get answers that are way different than for buyer's information only. And oftentimes there is a sharp difference of opinion between the selling side and the buying side as to what can be done with this. And I find oftentimes when it's a buyer that I represent, they tell me frequently, my agent told me I can cancel this contract if I don't like what I find. And I got news for you. There is nothing in that contract that gives a buyer walkaway power. Not unilaterally. You've got to go through the process first. Inspection, request, refusal to fix a defect. You got to go through the regular, that's the only way a buyer can cancel for an inspection related item. And so that is, I will tell you, I've seen a number of brokerages get sued for that exact issue. So I would be really, really careful. I represented a brokerage. I represented a purchaser last year in a transaction where an agent told their client, the buyer, hey, you can do your inspections. Seller's not going to do anything, but if you don't like what you find, you can walk away. And they did. They did their inspections and they tried to walk away, and the selling side went, I'm sorry, what? No, you agreed to buy this house as is. Buyer went to the office manager, and it's a brokerage that I represent, and the office manager called me and said, oh my God, I can't believe what our agent told this buyer. And there it is in an email, in multiple emails. And the brokerage actually did what I think was appropriate. They got in front of it and said, we screwed up. We're going to hire you. We're going to hire an attorney for you. It'll be your attorney, but we're going to pay the bills. And whatever comes down the pike, if the seller sues you for damages, we're going to cover those damages. Because the buyer's like, I'm not buying this house. I don't care what you do to it. I'm not buying. And so, you got to be really careful. But man, I will tell you what, I think inspection for informational purposes only is one of the most dangerous things that can be put in a contract for that exact reason. There's rarely a meeting of the minds. And I will also share with you when I often get called to come in, like when there's a problem in the middle of a transaction. I've made the argument, it's a very credible argument, you know, in order to have a binding contract, there has to be a meeting of the minds. So if when the contract started, I thought it meant chocolate and you thought it meant vanilla, we don't have a meeting of the minds. And so I've made this argument many times, and that is, if my client thought that they could walk away, and now I've got emails between my client and their agent saying, yeah, you can walk away. And the seller thought you're buying no matter what. We never had a meeting of the minds, and that actually makes the contract voidable. Meaning either party can void the contract because of the failure to have a meeting of the minds. And so it's, Mary, I'm really glad you brought that up, because it's, you know, this has nothing to do with this market. It's more prevalent in this market because more buyers are willing to, you know, give babysitting services for 50 years. Buyers will do anything right now. So there's more buyers willing to waive inspections. And so that's a major issue and a major problem. For sure. Great question.
Hello, how are you?
I'm good. How are you?
Good. Sorry about my voice. My voice is going. Have you seen something as small as if a CO is missing from the as is, someone's come back and sue for that? Because it seems like the agents that have been in the business a lot longer, for longer years, they say as is CO, certificate of occupancy, included automatically. I know that sounds like something small, but have you seen people get sued over things as small as that? If that makes sense.
Yeah.
Because if it's not in the MLS, which sometimes they don't specify it, then you can't assume that that's done by my client.
Right. So let's start here. The MLS is not part of the contract. So whatever the agent, whether you're on the listing side or buy side, whatever is in that MLS is nice as a marketing piece, but it's not binding. So even if the MLS says buyer responsible, if the contract doesn't say that, buyer's not responsible. So I don't know that I would say I've seen someone get sued over that. I've seen deals blow up over that, because if you're doing a deal in Willingboro or Pennsauken, or, you know, towns, Mount Laurel now went to a full CO not long ago. Towns that have significant, Pittman, another one, brutal, that have significant CO requirements. I've seen it come up as an issue. And so, you know, the contract as it's written, Section 9 requires a seller to get a CO. And so if you don't have something that reverses that, seller's responsible, period. And so if you're on the listing side and your expectation is that the buyer is going to be responsible, then in Section 43 or by addendum, you want language to say buyer responsible for all certifications. And so I would say just be cognizant. If you are doing a deal in a town that has significant CO requirements, you better make sure, even if you're on the listing side, again, your goal obviously is to get to closing, not to have a gotcha. So I would make sure that you start right from the beginning. If the buyer is going to have to get a CO, and it's a deal where a town is going to do, you know, it's going to be like another home inspection, better make sure the buyer understands that right out of the gate, even if you're the listing agent, so that everybody's aware. Pardon me, because if the house has got all kinds of issues, and you know there's going to be a laundry list of significant repairs that are going to have to get done, you better make sure that the buyer is willing and has the bucks. Because if you can't check both of those boxes, again, you set yourself up for failure. So I would look closely at that. And, you know, just go back to what Mary mentioned a minute ago with regard to that as is language. You also have to bear in mind when you have those as is deals. So typically these contracts are getting written by the selling side. And when there's an ambiguity in the contract, it's going to be construed against whoever drafted it. So, you know, if one section says X and another section says Y, that argument is going to go in favor of whoever didn't write that contract, even though you're just filling in blanks. And so, you know, when you do have an as-is deal, I meant to mention this a minute ago. Yeah, but I think it's section 25, 21 or 25. I can't remember. I think it's 25, where the seller makes a warranty. Give me 1 second. I'm sorry. Tell you right now. It is section 21 bulk sales. It's section 23. So if you have an as-is deal, even if you put all that language we talked about in section 43, section 23 says seller represents that all electrical, plumbing, heating, and air conditioning systems, together with all fixtures included with the terms, now work and shall be in proper working order at closing. So bear in mind that you have to get rid of that section also if you're really trying to do an as-is deal. Because otherwise, and you now have a contradiction in the contract. And so if you're a buyer, and I've been on both sides of this argument right before closing also. If you're a buyer and you've eaten a lot of what throughout the deal, you can fall back on that section because the seller has agreed to do all of those things. And so that is something that a buyer can use. So if this really is an as-is deal, you better make sure you get rid of that section also, because otherwise you can have a showdown right before, at any point in the transaction. But typically a savvy buyer is going to do it right before closing and say, hold on, take a look at the contract. By the way, everything's got to be working. So that's something that you want to keep in mind.
All right. Thank you so much.
You got it. Good luck with your voice.
Thank-
Anybody have any other questions?
Ben, can you open one section on the contract for me and maybe explain?
Sure.
I know what it means, but at least the agents can hear what this actually means. It's section, let's see here, 16 and line 367.
Buyer fails to void this contract within 7 business day period, buyer shall waive the right to cancel, and this contract will remain in full force and effect. That
Actually, last paragraph.
last paragraph.
If seller agrees.
Yeah. So again, another sort of anomaly in this contract. I'll tell you something, before we had this contract, my addendum used to be like 4 sections and now it's like 22. This contract, I think, is terrible. But it's what we have. So basically the way inspections are framed out is buyers 14 calendar days to conduct from the conclusion of attorney review, to conduct their inspections and make a repair request. The seller then has 7 business days to respond to that request. The buyer then has 7 business days to work it out with the seller or cancel if the seller hasn't agreed to fix all of the defects. And just as a quick aside, if the buyer's asked for 50 defects and the seller says yes to 49, the buyer can cancel. So let's suppose we're now in this, what's typical is there's, 8 or 10 items are requested and the seller says something like, we agree to do these 3, we're not doing these 2, and the other 5 items, we're looking into it, we'll get back to you, or something like that. You got an answer. That's a reply from the seller. It doesn't stop the clock from ticking. And this is a mistake I think that a lot of agents make. They're waiting and they're like, when am I going to get this answer? And a savvy listing agent is never given an answer. They've given you the answer. And so once you get that reply, once you do that, buyer now has 7 business days to either agree, negotiate, or cancel. At the end of the 7 business days after the seller's replied, if the buyer hasn't agreed, negotiated something else that's resolved, or canceled, the buyer accepts the property as it stands, and they've waived all their rights to inspections, and now they're going to closing. That's what that section says. And so what's real important to know is unless the parties have agreed to extend the time, when you get one of those vague answers that says, these other items we're looking at, we're having a contractor come out and we'll let you know after we've had the contractor come out, that's really not an answer. And it's a really good way to sort of tease a buyer along. And so as a buyer, the only way to really protect yourself, if now you're on the 7th business day after the seller's responded, if you're really waiting for an answer, the only way to really protect yourself is to send something over that says, we require this, this, and this. And if the seller doesn't agree, this correspondence operates as a cancellation under section 16(8). Contract's canceled if you don't agree. Or this is a cancellation. We don't want to cancel. You've left us no choice. If you agree to, I don't know, put in a French drain system in the basement, we'll reinstate. But you got to do one or the other, or you've waived your rights. And now you get, even though the seller's agreed to give you 7 out of the 10 things, if this happens, you get 0. You don't get any of them. Doesn't matter if they already agreed. That's the way that's interpreted.
So what does closing of title means in that section, if you look at it here?
Yeah. So to close title is just an old expression for closing. So sometimes you'll see when attorneys write to each other, they'll refer to it as the closing of title or the closed title. It just means closing.
Yeah, we had a issue with, I don't want to name the agent, but from Keller Williams.
Was it Christine Dash? No, I'm kidding.
No, it wasn't Christine.
Okay. All right. Then let's talk about it. Okay.
They had a walkthrough a day before the closing.
Okay.
And the buyer's agent sent me a notice that the works were not completed, so the buyers will not show up to closing. And I said to her, I said, look, read your contract properly, because you're going to be in trouble if you don't show up to closing. So the sellers came to the closing table, and everybody did except the buyers and the buyer's agent. And at that point, sellers sent a contractor out to the house at the time of closing to make sure that all the works were completed. And the contractor wrote a statement that all the requested repairs were completed like workman manner.
Mhm.
So now the sellers turned around and sued the buyer as well as the buyer's agents. And we also, went after the buyer as well. At the end, the judge decided to, get the buyer pay damages. Because that section on the closing of title section, that means that the sellers have right to finish all the repairs until the hour of closing. Is that correct?
Yeah, I don't know that I would specifically say it's embedded there, but there's nothing in the contract that says to the contrary. And so, I just was saying this to someone the other day. Part of really knowing how to use any contract, particularly this one, is it's not just what it says, it's what does it not say? And so, for example, when I represent a buyer, I'll put in my standard buyer's addendum says that all repairs have to be done no later than 7 days prior to closing. Buyer will have the right to conduct inspections of those repairs and so forth to ensure that they were done in a workmanlike fashion. If you don't have language like that, then yeah, buyer doesn't have any right to pull the plug if all the work has been done. And the next part of that answer is, it's not necessarily that it's got to be done to the buyer's satisfaction. There's nothing in the contract that says that either. The contract says the buyer can ask for a repair and that the seller can agree to make the repair. There's nothing in that contract that says the buyer has to hire a contractor or the buyer has to hire a licensed contractor. I put it in my addendum that the seller, in the beginning, that the seller, if the buyer asks for repairs, if they're over $500, the seller is going to hire a New Jersey licensed contractor. But unless the parties have agreed to that in writing, you can get a screwdriver and a hammer and make the repairs yourself. There's nothing that says you can't do that. You don't have to have a receipt. You don't have to have anything. You just have to make a repair. That's what the contract says. So I think that to me, I've had many of those cases. Where a buyer gets a little funky at the end and now they play a tug of war and a poker game of, well, I'm not coming to closing. Okay, that's fine. But, here's something I think very important to understand when it comes to these sort of debates that happen. And that's this. Number one, if you have a seller, no judge is ever going to force somebody to live at 123 Main Street. That's never going to happen. So if your buyer is an end user, he's going to move there with his family, whatever. If they're an end user buyer, it's going to be primary residence, you're never going to compel the sale. So it's just a question of damages, which I'm going to touch on in a second. However, if your buyer is an investor, a flipper, a corporation, whatever it is, that's a different story. In those cases, you can compel the sale, and I have many times. And so you got to know that, number one. Number two, right now, it's actually not easy to get a buyer to be responsible for anything if they walk away from a deal, because even if the buyer is in breach of contract, so let's say they're in default. In your scenario, they're in default. No doubt about it. But if again, using the same stupid hypo I've been using this whole time, if they're going to pay $250 for the house and you replace them with another buyer at $250 or God forbid $260, it doesn't matter if the buyer looked at you and said, I'm not buying your house, I'm going to breach this contract. That doesn't matter. The seller doesn't have actual damages. That's the next part of the puzzle. It's not just whether they breached, and was the seller actually financially harmed as a result of that breach? So I have a scenario where my client's got a $100,000 deposit that's being held hostage because of a scenario similar to what you're talking about, and the seller refuses to release it. And I now have a copy of the recorded deed. They sold their house. Seller sold their house for more money. So we just filed a lawsuit. We're now seeking punitive damages. I'm not going to get it. I probably won't get it, I should say, probably, but we're seeking additional damages because the seller sold the house for more money than my client had initially agreed to pay it. I wasn't in the underlying transaction, but there's no actual harm. So the question isn't just did they breach, it's did the breach and was the seller actually harmed? Here, the seller actually got a windfall by the breach. They got more money. So you have to know if you're trying to impart this information to a seller, that, hey, it's not, you can't just not that you can't automatically file a lawsuit, but you're going to be wasting your money on attorney fees, because if we sell the house for basically the same price or more, you lose, even if it's just a flagrant breach of contract, you lose because of that. So in your case, it's great that the judge saw it that way. I'm actually surprised it actually went to verdict. Was it under 50? Was it under 15,000, the damages?
More than.
So that went a long time. If that went to trial, somebody paid a lot of money.
Well, the thing is, the sellers end up selling it less as well. So
Yeah.
that was another thing.
Yeah. Well, and again, if they've sold it for less, then yeah. And so there's there's a number of things we can do. One of the things that I do in my buyer and my seller addendum is I include language that says, in the event of litigation related to the property, whoever wins gets their attorney fees paid by the other side. And I always sort of give the same stupid little joke. And I say, look, I'm not suggesting this because I'm secretly hoping you're in a litigation, my kids go to Harvard instead of community college, but for the exact opposite reason. And that's this: in breach of contract, doesn't matter how bad the breach is, how flagrant it was, you're not entitled to your attorney fees. So if you have a situation where maybe somebody is out 20,000 as a result of breach, and they're going to spend 50,000 to litigate that case, it doesn't make any sense. And so there's often very little downside to a buyer breaching a contract, especially in this market. There's often very little downside to a buyer just taking the contract, tearing it in half, and sticking their middle finger up at the seller, unless attorney. So you're not entitled to attorney fees unless it's in the contract. If it's in the contract, that's a different story. So I always recommend putting it in there, and I will explain it to the other side. If I don't have an attorney on the deal, I'll explain it to the agent on the other side. Hey, listen, after having done this 4,000 times, I recommend putting this in there to keep everybody acting reasonably under the circumstances, because if you don't, you may end up paying not one, two lawyers for your right to be a jerk. And so I put that in there really as a fail-safe, so that you don't have those situations, because my guess is if you had a provision like that in the deal you're talking about, maybe that buyer would have thought twice and closed. If so, maybe not. You know, look, there's lots of crazy people out there, but I will tell you that there have been many times where I think that has made a substantial difference in keeping deals on track and helping people find religion a little bit faster during the transaction. So, yeah. What else? Any other questions? Nathan? Okay. Guys, I really appreciate you giving me the opportunity to talk to you. I think I'll be talking to you next month. I have to look at what Mary sent me. In the meantime, if you have questions, feel free to reach out. I'm also, and I think Mary, I think we talked about maybe doing a session specifically on a Q&A on any topics, and so forth. So just, setting one up for you guys to submit questions and stuff like that. And then I can try to answer them for you. But I appreciate the time, and it was nice sort of seeing you, and I'll look forward to seeing you guys soon. Okay.
Thank you, Ben.
Thanks. Thank you. All right. Take care. Bye now.